Hello, Your Honor, and hello, Paolo. How are you guys doing?
Great, thanks.
Great, thanks for having us.
Well, it's nice to see you again, Your Honor. You're a recurrent guest of the show, but Paolo, it's very nice to have you here for the first time, and hopefully it will be the first of many times to come. I'll let you, though, introduce yourself because it's your first appearance on the show, Paolo. Not to put pressure on you, but it's nice for people to know more
First
about you.
time, first time caller, long time listener.
Yeah.
My name is Paolo Giancaterino. I'm a criminal defense practitioner based out of Ottawa. I practice throughout the East region in Ottawa and other smaller jurisdictions, including Cornwall, Pembroke, Perth, and Lauderdale. I can't remember when I was called, 2007 now. So it's almost been about 20 years at the bar and involved in criminal defense and absolutely love it. And looking forward to doing this presentation or this meeting.
Well, thank you for being here with us. And of course, Justice Jones needs no introduction, especially on this series. We often have you as a guest here, Your Honor, an OCJ judge sitting in Toronto at 10 Armory. And Paolo, for those who don't know about Paolo, he's a very busy trial lawyer, always doing trials. And he actually has a mini break right now, so which is great. So we can record this episode because what we're going to be talking about today is a summary of some of the important cases that came out in 2024. And so that's going to be used as a good tool for lawyers who just want like a review of the year, let's say, in terms of case law. I will let you guys cover the cases that you found are really important that we should bring to the attention of our viewers. But I'll start by mentioning two cases. I won't get into detail just because we did cover them either in an interview or through the bail conference, and those are the cases of Bykovets from the Supreme Court. It is a case that came out early in March of 2024, and it is about IP addresses where the court recognized that there is a reasonable expectation of privacy in an IP address. There is an interview with counsel for Bykovets. If you go back and you check those interviews, you will find that, and we covered this case in depth. But this is an important case that came out last year that everyone should be aware of. The other case is a case by Justice Jones, Nanibush, which is now now reported. It was unreported for a while, but it was just recently reported, and you can find it online. Nanibush is important in the bail context because it is about the situation of an vulnerable accused, people who don't have a bail plan, no surety what to do. And this is a really good case to rely on if you have a bail hearing and you don't really know what to do, what kind of plan to offer. This case was covered at the bail conference, so you can just review the panel that we had about that, and you'll have more information about it. And of course, you can read the case, it's reported, you can find it online. So, going now to you guys. So we have grouped the cases that we want to cover by topic. Um, the first topic I think we're going to start with is 11B. So I don't know who wants to jump in first, but let's start with some of the important cases about 11B from 2024.
Go ahead.
Sure. Well, I think we can pretty much say that 11B is close to extinction. I think from a lot of the cases that we've seen. However, there are really a lot of really good cases out there that deal with specific situations where the Crown is attempting to put the delay on defense counsel, and these are things that we're seeing on a regular basis when it comes to 11B applications, and even more recently, where I think we can safely say that we're seeing a lot more stacking of trials within jurisdictions to try and deal with the excessive amount of cases that need to be dealt with. So the first case that I thought would be interesting to talk about was a local case here in Ottawa, a case by the name of the King and Hughes. And it was a decision released in April of 2024 by Justice Matthew Weber, former defense counsel turned judge extraordinary here in Ottawa. And this was an interesting case because it dealt specifically with that situation where a trial date, a multi-day trial date had been set for an accused person, and it wasn't reached. Um, and to further complicate things, there was I can't recall if it was an out-of-town judge or a per diem judge that was initially supposed to hear the matter. So essentially, what happens is on day one, the matter's not heard, it's adjourned to day two, and then about halfway through the day, the court becomes available. But then the question is, do we start now in front of a judge where we know that their availability is not going to be as great as a local judge? And ultimately, it was decided that with input from the court that the case wouldn't start. So the parties got together, the Crown and Defense got together, and the trial coordinator gave some fairly speedy dates in terms of where they were in January, and there were some dates that were available in March where defense counsel was not available. So I think it was anywhere between 6 to 8 weeks from the original trial date, and then ultimately they settled on some dates that went past the Jordan date of 18 months. And so defense counsel rightfully brought an application, and as is the case in these 11B situations where the Crown respondent is saying, well, the defense needs to shoulder some of the delay because we had dates where the Crown was available, the court was available. And I'm talking about the second subsequent set of dates, but defense counsel weren't available, and those dates were within the Jordan timeline. And so Justice Weber, goes back in terms of the authorities and reiterates what was indicated in Godin that defense counsel don't have to hold themselves in a state of perpetuity. And then I think what's really interesting in this case is that Justice Weber talks about some of the more prevalent issues that we have going on today, and what is expected of defense counsel. So where an original trial date is not going ahead, and then subsequent dates are offered and defense counsel is not available, what to do in those circumstances. And I think the ultimate message from Justice Weber was that the administration of justice needs to be sensitive to the fact that it's not only the courts that are under pressure, it's not only other participants on that side, but defense is under a lot of pressure as well in terms of trying to squeeze in trial dates. And it's difficult, as we all know, even though you might have prepared for a trial and it doesn't go ahead, to then try and find dates that are within a short amount of time that fit within your schedule, that allow you to do everything else within your practice. And Justice Weber was really sensitive to that, and he drew upon Justice Schreck's decision in a case called Bowen Wright to talk about the fact that it shouldn't fall upon members of the defense bar to compensate to make themselves available on short notice in order to comply with 11B, where for one reason or another the court wasn't able to reach the case on the first date. And despite the fact that counsel tried to made every effort to try and find dates that worked, that were Jordan compliant, it just didn't work. And ultimately, what Justice Weber had indicated was that where there is stacking that's going on and there are multiple trials going on and a case doesn't get reached, and defense counsel is then not available later on for a subsequent date that's being offered, that shouldn't lie at the feet of the defense. And defense is going to try and accommodate, but if they can't, this is threatening to bring things back to business as usual and that culture of complacency that we talked about previously. So I think it's a really good case to have in your pocket when you're faced with situations like this, where there's a stack, your trial doesn't go ahead, and then you're being pressured into trying to find dates, and if you're not available, you're not available.
No, I mean, I think that's very well said. Incidentally, I really want to thank Paolo for putting together a list of the majority of these cases, because we're going to talk about some big appellate decisions that matter, obviously, from the Supreme Court and appellate courts across the country. But a lot of these, trial judgments are kind of hidden gems, right? That really touch on issues that are going on the ground, in the trenches that people should know about. In addition to everything that you just mentioned, something I just want to bring to everyone's attention, at least if you're appearing in the Ontario Court of Justice, right? I can't speak for the Superior Court, is we have the Jordan Compliant Trial Scheduling Directive. And it's important that you're just familiarizing yourself with that and what it requires. What's supposed to be happening now, right, is that after 6 months from the date an information is laid, regardless of the status of disclosure, regardless of other steps that have been taken in a case, trial dates are supposed to be set within about 15 months to give a target, right? So people are moving towards that, and there will be stacking, I think, in most courthouses accordingly. And then as a result of that, some cases may or may not be reached. But the point of this new directive was to avoid things just dragging ad nauseum forever until finally people decided to set a date. And I know in the Hillier case that you included as well on our list, right? One of the biggest culprits sometimes in these things dragging on is just the lack of disclosure, right? And when things aren't provided in a timely manner. So a lot of the old case law is still going to be important. Of course, Jordan itself and everything else about the duty of the Crown to provide meaningful disclosure before matters can be set and moved along. In cases where an election has to be made, there's a very strong defense argument to say, look, we can't really make a decision on how we're going to elect until we get this. But especially for those pure summary conviction cases now, that directive is supposed to be enforced across the province. And you may find yourselves in situations, I don't know what's happening in Ottawa or in other jurisdictions, but in Toronto, we're pretty strict about enforcing it now. The dates are set and we're stacking lists, and then there may be consequences of that down the road, and how all that plays out for future 11B applications will be interesting to see, because I don't think there's much case law, if any, that's developed around this directive per se yet. But you definitely want to know about it, and it's on the Ontario Court of Justice's website if you haven't seen it yet.
It will be interesting to see what happens where we see more and more of these, the directive being enforced and trial dates being set, and maybe not all disclosure has been provided, and then something comes up, especially in sex assault cases, where suddenly there's going to be the need for a 276 or 278 or a combination of the two in terms of applications, and what happens with that trial time, and what happens if you can't fit it in, and what happens if it goes over the Jordan timeline? Like, who's going to be at fault there? I would hope to think that defense counsel going ahead and setting dates, and who are not responsible for getting disclosure into their own hands, would not find any fault for it. But it'll be interesting to see what happens, because I think eventually it will happen if it hasn't happened already.
The other interesting area to watch, I would say, too, are potentially developments about stays below the ceiling. In Toronto, at least, I can tell you that one of my colleagues stayed charges where disclosure had been so inadequate for so long that even the total delay being about 16 months, and therefore an under the ceiling application, was granted. And then the Crown appealed that to summary conviction appeals, and we're going to see what the outcome is there. But this is just a constant issue. And I know the pressures that are placed on police forces and Crown's offices to process everything now. But that being said, an accused person has the right to receive their disclosure within a certain amount of time and to make important decisions about their case. And sometimes delay accrues, right, simply as a result of that. And I think the Hillier case that we include on the list is a good example of that, at least for part of what that decision stands for.
Yeah, I think that's a good segue into that Hillier case, which is another Ottawa decision from the Superior, this time from the Superior Court. Justice McVeigh, former Crown attorney, who was just recently elevated to the bench. And Hillier is a really interesting case because again, as Your Honor indicated, this is maybe one of those exceptions to being forced to set dates where disclosure is still lacking, where the Crown is proceeding by indictment. That really seems to change the landscape of what pressures there will be on a defense counsel to set dates when disclosure is missing, and you don't even know which court you're going to elect, whether you're going to have a prelim if you're eligible for one. So I think that what Her Honor does in this case is set out what I think are the basic principles now of 11 being disclosure, that defense counsel don't have to wait for every single piece of disclosure and can move their case along. But where there is disclosure that's lacking that has an effect or could have an effect on the decision-making surrounding an election, This is going to be something that needs to be provided to the accused before they're going to be called upon to either, plea or elect their mode of trial, because it's such a fundamental, important decision, right? And as we know as practitioners, the accused person, they have a couple of choices to make where defense counsel can't overrule them, whether to plead guilty, or whether to proceed to trial, whether or not to invoke their right to silence, or whether to testify, and obviously their mode of trial, whether they want to go to Superior Court or the Ontario Court of Justice. We're not making those decisions. The clients are, and it's important to ensure that you have the appropriate disclosure so that your client can make that informed decision going forward. I think a couple of other key points from the Hillier decision, again, that I think can be useful going forward is where, and these situations arise where defense counsel may be, I don't want to say forced, but maybe prodded to set pretrial motion dates that are that are past the timeline for dates of service. So as we all know, there are requirements in terms of service of application materials, and there may be situations where earlier pretrial motion dates are available, and they won't give either any time or very little time to prepare materials to provide them within the timelines that either the OCJ rules or the Superior Court rules require them for. So that is, Her Honor speaks to that and says, look, you can't start forcing defense to, bring these pretrial motions within a very short time period, because even if they do get the materials in, the Crown still needs to respond, and it's not fair to all parties, including the court, to move on this type of basis. And so, there still is a requirement that you need some reasonable time to prepare these materials. I mean, it's part of the advocacy process, and it's doing everybody a disservice to force you on simply for the sake of expediency. So,
Well, Paulo, sorry to interrupt, but I mean, I find like this is the frustration that we're feeling at the trial level, is that 11B is being prioritized over the quality of the work in the defense. It's like you have to move quickly, and it doesn't matter if you're well prepared, if you have, like all we care about is 11B. So, but it is a pressure that we're feeling, at least on the defense side, because then it's always this kind of bargain that you have to do. It's either you prioritize your 11B right, or at the expense sometimes of the quality of the work. And I mean, like, so this case is really talking a little bit about that and that frustration, I guess, like, from like,
yeah, I mean,
whether.
it's not reason. I mean, you're right. Like, it's not reasonable to expect, for the sake of expediency in getting dates for pretrial motion dates to be set, 2 or 3 weeks, in advance of the date that you set them, and to expect materials to be prepared, served, and then a response formulated, and then preparation for the dates themselves. I mean, there's a reason why we have these rules put into place, and they're for the fairness of all parties, not only defense, but as I've said, the Crown and the judiciary. I mean, which judge wants to receive response materials a day before an application, especially,
Maybe Justice Jones.
yeah. I'm sure you love receiving materials the morning of or the day before, right? Where you're looking at a 15 case book of
Yeah.
authorities, right? And again, I mean, these are oftentimes these pretrial motions. If they're not determinative of the actual issue at trial, I mean, they have a profound effect on what's going to happen at trial. And then you don't forget the fact that there's still maybe a trial upcoming, and the judge needs time to decide. So, I think this is this is a really good call by Her Honor in terms of pointing this out and saying, we need to work together to try and move things along, but there are situations where we're not going to put people in a position, or counsel in a position, where they're just not able to fulfill their basic function.
I got nothing else to add about 11B. I will just say this. Everyone should know that the Supreme Court granted leave to hear the case of the King and Jacques Taylor, pardon my terrible French there, that will be heard at the Supreme Court, I believe this year now, obviously, on 11B. More to do, I think, with what happens when counsel for a co-accused is not available when dates are set and how that should be attributed. But we're almost on the 10-year anniversary of Jordan. You never know. Maybe the Supreme Court will use this as an opportunity to take all of our frustration away and somehow simplify this, right?
And Hillier's under appeal as well. I
Oh, I didn't
forgot
know
to
that.
mention that. Yeah, so the Crown filed notice of appeal on that. The last thing I did want to mention about Hillier as well is one of the arguments that the Crown made to say that they attempted to mitigate the delay was to attempt to set what they referred to as provisional dates, right? So this was a novel situation where there was a change of venue issue to be dealt with, but the Crown suggested, well, the delay could have been mitigated had defense set a 4-week block of time of trial in the Superior Court in Ottawa in case the change of venue motion failed. And interestingly enough, Her Honor really didn't like that suggestion for a number of reasons, and one of them was obviously the fact that court dates are at a premium, both in the Ontario Court of Justice and the Superior Court, right? Trial coordination shouldn't just be in a position where they have to hold dates and then say no to other matters that are actually ready to go to trial. And then the second, and I thought this was interesting because oftentimes defense counsel are forgotten in all this, but the fact that we can't lose sight of the fact that defense counsel is going to have to set that 4 blocks aside. Like if we set a provisional date, dates, we can't book anything else in there, right? And so if those dates don't go, suddenly they become vacant, and what are we going to do, right? If we're not doing anything during that time, as we all know, we're going to suffer financially, and so that's something that may be passed on to the accused or to the client, right? Saying, well, I booked 4 weeks set aside, it didn't go ahead. I'm going to charge you for those 4 weeks, and then the next 4 weeks that we set for the actual trial itself. So I thought some really good insight by Her Honor on some of the more practical problems that we may encounter, at least from this side of the bar.
And that, of course, that's if it's a private retainer. If it's a legal aid file, legal aid is never going to pay a defense lawyer for that.
We have a hard enough time getting money for the work we do.
All right, so these are the 11B cases that we wanted to cover. Then the next area was youth-related cases.
Yeah. So one interesting youth case that I found was a case called TM. And TM was a case that was decided in May of 2024, and I believe the jurisdiction was Hamilton. But this was a case where an application was brought to challenge the constitutionality of sections 42 sub 2 sub P and 42 sub 5 sub A of the WiCCD, and those are the sections that allow a court to provide a deferred custody and supervision order to a young person, what we also know as akin to a conditional sentence order, right, where the youth is bound by terms and provisions to serve their sentence in the community. And what the WiCCD does in terms of their regime when it comes to these deferred custody and supervision orders is, firstly, they limit the length of time that they can be imposed for to 6 months. And then the second is with respect to the statutory requirements, and one of the requirements or one of the prohibitions of giving a deferred custody and supervision order is if a young person causes or attempts to cause serious bodily harm, and that's the offense for which they're being sentenced for. And what the issue was is that we all know that I can't remember, I think it was last year or the year before, is that Parliament amended Section 742 of the Criminal Code dealing with conditional sentences. So you may recall that there were a number of statutory prohibitions to imposing a conditional sentence, one of which included cases that involved causing bodily harm. And so what ends up happening because of that amendment, you get into this really weird situation where an adult for an offense where they cause bodily harm can obtain the benefit of a conditional sentence order, whereas a youth who may have committed the same type of offense cannot. And that necessarily conflicts with so many different, as Your Honor will I'm sure reiterate, it conflicts with so many provisions within the WiCCD that talk about, what the WiCCD was intended for. And that was, first of all, to reduce over-reliance on custodial sentence for young offenders. And secondly, things like, some of the principles of sentencing when it comes to young persons, the fact that young persons should not receive a sentence greater than what an adult would in the same situation. And this had, the change by Parliament of the criminal code of 742 resulted in this disparity between the WiCCD and the criminal code. And so a constitutional challenge was brought both under Section 15 and Section 7. Again, in the Section 15 analysis, the court talked about the disparity between the provisions in the WiCCD and 742.1 of the criminal code, and ultimately found that the provisions that limited the availability of the deferred custody and supervision order in the WiCCD was discriminatory based on age, which is an interesting and novel argument, I think. And a lot of the Crown's argument in this case was based on the fact that a judge in sentencing a young person has the ability to, has other tools available, so they can provide them with, probation order that has owner's provisions in it, or they can send them to custody, right? And I think the court did a really good job of saying, well, that doesn't help because there may be situations where probation is inappropriate and sending them to jail is inappropriate. And that's what that happy medium of the deferred custody and supervision order is supposed to do. So you can't provide, whether it's a youth or an adult, you can't provide them with an unfit sentence because the sentence that would be fit is just too onerous for them. So sending them to jail doesn't mean you can give them a probation order if that's outside the range or if it's unfit. So I think a really good job by the court in this, and they also spoke to the limit in terms of time that you can apply the deferred custody and supervision order in the WiCCD, because as we know, in the criminal code, it's 2 years less a day, and in the WiCCD it's 6 months. So the court also found that was discriminatory and struck that down, and then ultimately relied upon some of the same arguments in their Section 7 argument, and said, a young person is being deprived of the benefit of community-based sentencing order because of the age, not because of the offense committed. And again, that negates a number of the statutory provisions of the WiCCD that are aimed to give meaning to the principle of diminished moral blameworthiness for young persons.
So I'll just add the following. If you're going to rely on this case in the Ontario Youth Court of Justice, i.e. you want the next judge just to follow this, okay, and to accept that the other judge did the correct thing and the same remedy should result. Remember, you should be filing a notice of constitutional question, technically. You should be citing, in my view, this case and then Sullivan from the Supreme Court, just on horizontal stare decisis, and effectively saying that, the next court must follow Justice Kamara's decision, even if the court might not have come to the same conclusion itself, because there's no reason to suggest that, that what are called the Spruce Mills criteria are met for why I wouldn't follow one of my colleagues, but you do need to follow those steps. The Crown's at least got an opportunity to respond. I can tell you in Toronto, at least the Crown's office seems to have taken the position they're not litigating this. They just accept it as long as the steps are followed. Although I have been told that they have appealed it straight to the Court of Appeal, I believe, although no date has been set for that appeal hearing as of yet, as far as I know. So that'll be one for us all to watch. I'll be very curious, quite frankly, to see what the Crown argues on the Section 15 equality rights issue. That feels like an uphill battle, but you never know what might happen. But for now, at least in the Ontario Court of Justice, where 99.9% of youth cases are going to be decided, if you're defense counsel and you want to rely on this, just make sure you follow the right steps. Very relatively straightforward to do. And then the rest of us should be following our colleague.
Yeah. And just as a practical tip, when you need to serve the AG of the province and of the federal government, that's all available online. Filing the notice of constitutional question, they accept it by email, and I'm pretty sure that in most cases they don't actually attend or they don't appear, but you're still required to give them that notice as His Honor has indicated. So.
Why don't you take us through ES and why you thought that one was worth talking about?
Yeah, so ES was a case that I did in Pembroke, and it was an interesting case for a number of reasons. So it was an allegation of sexual assault that was alleged to have taken place in 1982. So during the time of the Juvenile Delinquents Act, so before the enactment of the Young Offenders Act, and obviously before the enactment of the Youth Criminal Justice Act. And what made it even more interesting was the fact that both the complainant and my client were considered youth at the time. And so it was an allegation that my client had sexually assaulted the complainant when he was babysitting her. And I included it because I like a lot of the language that Justice Richardson uses throughout the decision, and some of the language he uses, I think, takes head on this whole, the Me Too movement, in the sense of, I believe the victim, right, and that we should always initially believe the victim rather than let due process run its course. And, His Honor really does a good job of talking about how the fact that criminal law is a blunt instrument, and, we are always, judges, I should say, are always on guard for wrongful convictions, and we shouldn't fall prey to, thinking, why would the person lie about this, or how, why wouldn't we believe this young person because they said that this happened? So a really good job by His Honor, and then talking about the differences between reliability and credibility when it comes to determining how much of a witness's, if any, evidence that you're going to believe, and takes some of the language out of Morrissey and just puts it in a very plain and easy to read paragraph. The other thing that His Honor talks about, which I found interesting, was in these historical sex assault cases that you have to be mindful of situations where, and again, this goes to the reliability issue of a witness's evidence. They may be credible in what they say. They may come across as credible, but we have to be wary of reliability when it comes to things like filling in the blanks of what had taken place, right? So where you have to be on guard for aspects of a complainant's evidence in these historical cases where they may be filling in the blanks of what happened or their evidence based on logic, reason, and common sense, right? And ultimately, where you find issues with this honest and sincere and credible witness ultimately may not be reliable. And again, as I've mentioned, His Honor talks about the fact that there is some public sentiment out there about the fact that people may not think that enough convictions happen for sexual assault cases, right? And they talk about, I don't want to say talk about, but they demean the process, and they demean, some of the golden threads that run through our criminal justice system by, calling proof beyond a reasonable doubt something like a technicality, which is something I absolutely hate. And It's some really strong language about,
It's a bold submission.
pardon me?
That's a bold submission if someone does
Yeah,
that.
right. So, ultimately, at the end of the day, it was an interesting case that also touched upon the fact that we know that the Supreme Court of Canada has over and over and over again discussed how trial judges are to analyze the evidence of youthful witnesses or witnesses who were youth at the time that the offenses took place, and how you can't always rely on minor inconsistencies to say that this person's lying or they're not telling the truth. And the interesting aspect of it is that His Honor also agreed with me that the fact that my client was also a youth at the time, they would also benefit from this case law from the Supreme Court of Canada, where there may be minor inconsistencies, but you have to recall and remember that the accused, as well as the complainant, were both young persons at the time, and that their evidence needs to be treated equally and fairly in terms of any leeway that you might give them for their age at the time of the offense. So that's why I thought it was an interesting case, and touches a lot upon a lot of first principles when you're dealing with historical sexual assaults and sexual assaults involving young persons.
Maybe I can use that, if you're okay with it, Maya, then just as a segue or a springboard into two of the cases that I wanted to talk about. Everyone just has to know about these. It's difficult to put into words how complex and time-consuming I know sexual assault cases are for everyone involved. They're difficult. I'm sure they're very stressful for your clients. No doubt, they involve a lot of pressure on complainants and everyone else too. Believe me, trial judges are not immune from that. But we had two big decisions come out last year on 276 applications in particular. And I just want to make sure everyone knows about. You've probably already heard about them. I won't dwell on the facts in the interest of time, but you had TWW from the Supreme Court of Canada and then Reimer from the Ontario Court of Appeal. All I can say is that these applications are certainly complex and involve a lot of difficult analysis. You need to know about these two cases, and you really should be including them probably in almost any application that you bring or respond to. In TWW, all I will say is that one interpretation of this case that I see sort of taking off among the lawyers that come before me, at least from the defense perspective, is that it's arguably made it even harder to succeed on a 276 application, simply because the Supreme Court uses very strong language in the decision to say, that the evidence sought to be introduced has to go beyond just some sort of general ability to undermine a complainant's credibility or provide helpful context, right? It must respond to a specific issue that could not be addressed or resolved in the absence of that evidence. And indeed, there's other language in the decision that says, in the absence of the evidence, would the defense position be untenable or utterly improbable? I think one of the arguments I'm often just faced with from, especially younger defense counsel, very earnestly, is the argument that, well, Your Honor, this is relevant. It's not being introduced for a twin myth. And there may be truth to that, but sometimes relevance just isn't enough because the standard in that section, right, doesn't say, well, simply because it might ostensibly be relevant, therefore it's admissible. Far from it, there's a bit of an uphill climb there. So just look at that decision, look at how the Supreme Court explains how it decided it there. It's the most recent authority. Obviously, I must follow it. All my colleagues must follow it. And make sure that you're on top of it. If there's any nuance, I'd love to hear about that too. Reimer is a lot more, I think, interesting just because it's a bit more controversial. It's a case involving two people ostensibly getting together for an intimate encounter, and they're texting each other beforehand, right? This is just what people do now. And the text messages become the flashpoint of a lot of the court's analysis, because in the text messages, there are communications between the accused person and the complainant about what is or is not going to happen when they meet up, and whether or not the complainant has expressed an interest in potentially engaging, right, in sexual activity. Well, can that be introduced for a lawful purpose, or is it irrelevant, right? Simply because, of course, consent has to be obtained at the moment of the sexual activity in question. And the fact that someone might have expressed an interest in agreeing to that previously maybe is of no moment necessarily, right? This is where the debate is often being had. And Justice Picacho, for unanimous decision, the Ontario Court of Appeal says, no, these prior communications can be admissible and relevant because they're not engaging in twin myth-based reasoning. There's just a statement there of an intention to engage in future conduct. and it is a relevant piece of evidence to consider when deciding whether or not consent has actually been made out, or at least there's reasonable doubt on that point. I know that the Crown has sought leave to appeal this to the Supreme Court of Canada, but if you have one of these cases now, and if you're defense counsel and you're thinking of trying to introduce, especially text messages, but maybe other forms of communications between the accused person and the complainant, that you might say lawfully can be used to help raise reasonable doubt on whether or not there actually was consent, even though the complainant presumably is saying there was not consent at the time of sexual activity. Read this case carefully, see how Justice Pacocho draws the lines between what is and is not twin myth-based reasoning and when this can be admissible. I don't want to get into the gory details here. We'd be here forever, but it's really interesting, and it is the leading case in this province, for now at least, and it should be brought, in my view, to every judge's attention in one of these applications. And expect a battle. You know, the Crowns are going to say there is something that can be distinguished, or in some cases they might even, point to the fact that it has been appealed, although I don't know what that necessarily gets them, at least in this province temporarily. But those are the two big ones that I thought of. Oh, I'm sorry, my lights just dim. Now I look like a specter or something. I'm really not that bad a guy. Okay, go ahead, Paolo. Do you want to add anything about those two?
Well, a good segue now into one of your cases, because you mentioned Justice Pacheco, is the ML case that Your Honor released in August of 2024. And the reason why I say it's a good segue into from what you said about Justice Pacheco is because you mentioned Justice Pacheco in one of the paragraphs dealing with the issue of sentencing persons for offenses of sexual assault. And I really like the comment you made. It's at paragraph 75 of your decision, talking about the RS decision, where again, going back to that actual case itself, where a conditional sentence order was imposed upon I believe it was an Indigenous offender for a sexual assault, and the Court of Appeal, on a 2-to-1 decision, Justice Pacheco in the minority, decided to overturn it and impose a 3-year sentence. And this really caught my eye, Your Honor, where he said, "I also don't understand the majority's decision to disagree with Justice Pacheco's concurrent reasons on the general availability of CSOs for sexual assault, while acknowledging that each case turns on its facts." I think that's a pretty a succinct summary of what we were all thinking in that decision. The reason why I found this case interesting, and obviously you're dealing with sentencing a racialized accused person for a sexual assault, was one of the things you had to grapple with first and foremost was the imposition of whether or not a conditional sentence was appropriate in the circumstances, and ultimately you found it was not, given the nature of the offense. But the interesting portion of that case that I think is important is your analysis as it pertains to the SWAR order, the imposition of the SWAR order. And as we all know, the I don't ever know if I pronounce it right, but the Ndlovu case struck down the prior SWAR provisions, and then Parliament responded by amending the criminal code to allow some discretion in certain circumstances for a trial judge to not impose the SWAR order. And I think Your Honor picked up on a number of aspects that defense counsel should focus on if these obviously apply in the circumstances of your case, where you're dealing with sentencing an individual for a sexual assault. So obviously, the determination of whether or not that person is a low risk to reoffend if they engage with counseling and program as part of the rehabilitative portion of a sentence. Now, I know that you don't necessarily need to get an SBA or a sexual behaviors assessment in order to show that low risk. That could be accomplished maybe through a pre-sentence report or other extraneous material. But certainly, if there is evidence out there that your client, it's a bad decision made, in an otherwise, clean and pro-social lifestyle, that would seem to suggest that this person is going to be low risk to offend, and certainly with them participating in any preparation of reports and anything else dealing with sentencing, that may show that they're going to comply and meaningfully participate in any rehabilitative efforts. which would suggest that a SWAR order is not required. But I also liked Your Honor's discussion on just how serious the imposition of a SWAR order is. I mean, I mean, we may think a SWAR order, okay, well, you have to report once a year, and to the police station in your jurisdiction, and you have to report any changes of address. But I think Your Honor delves into what actually happens with a SWAR order, and what effect it may have on individuals, and the significant burden that it causes, right? So, for example, structuring travel and residency so that you're in compliance. Um, the fact that you may be dealing with marginalized individuals who may not have a day planner, who may not have the ability to keep track of all of these requirements. They may be persons of limited means. They may be persons who rely on the shelter system. So these are burdens that we place on these individuals who may not be able to comply with it, who don't require it because they're of such low risk or manageable risk within the community. And the fact of the matter is, a violation of SWARA, I don't think I've ever seen a case where jail hasn't been imposed for it. I mean, it's taken extremely seriously along the lines of, if somebody breaches an LTO, like a long-term offender condition, then oftentimes that person is sentenced to a fairly significant amount of time. So that, along with the length of time that the person is burdened with this reporting, that is something that we often don't have in our thoughts when we're talking about these SWAR orders. That it's not the length of a probation order; it's decades that a person is going to have to report. And then ultimately, how Your Honor ties it into, well, what's the purpose of SWARA, right? They're there to assist police with investigation, to try and prevent sexual-based crimes. And the fact of the matter is, and you'll probably see this in a lot of cases, that the Crown often doesn't lead any evidence at sentencing talking about how registering a person in the sex offender registry is going to advance the prevention or investigation of these crimes, especially in the context of the offender before you. And ultimately, I really like the language that Your Honor used, talking about the fact that putting someone on a SWAR order, and I think you use the term, it's a grave matter. I mean, that reflects the seriousness of these orders, and just the type of burden and the consequences that can be placed upon an accused person if they are subject to one in circumstances where it's not needed, and it's not needed. And it may have ultimately a detrimental impact on their ability to reintegrate and rehabilitate themselves back in society. So that's what I found really interesting, and I implore people to, if you get that case, it goes from paragraphs 92 all the way to 100, and there's a lot of good language in there to use.
I will not shamelessly comment on my own decision. I will simply say, don't forget that a SWARA order isn't necessarily mandatory now in many cases. Look at the provisions in the code, look at what the exceptions are. Look at my case, obviously, look at other cases. I cite a few others in there as well. This is an interesting area that's just developing after the Supreme Court's decision. And the Crowns will make principled arguments too. And I really do want to compliment both lawyers in that case who just did an exceptional job on this whole argument. I found it fascinating. It's actually the only case I've had where it's even been argued since it became discretionary. So I'm not saying in every case defense counsel will want to make the argument. In some cases it may obviously not be one that's likely to succeed. But think about it at least. Give it some thought, and seek guidance from other members of the bar who might be able to make some strategic suggestions to you about how to do it.
Now, I mean, it's not to talk about a case in particular, but on this point of the orders, I mean, the same thing also applies to DNA orders because, I mean, sometimes lawyers, we don't argue against them, but clients don't like to give their DNA. So there are some situations where they're really unnecessary, but the Crowns will still ask for them. So it's also try to fight these orders as much as you can because it is a part of your client's bodily substance that you're giving out to the police for free. So it is a big deal. Like it looks like it's not a big deal. It's just an order. No, it is a big deal. So
there's nothing wrong with resisting, especially if it's a secondary designated offense.
exactly.
the position of the defense is we don't accept that this is an appropriate case or the Crown hasn't met the test. Really, it's the Crown's application at that point. You're sort of just asking the Crown to establish why they argue that the standard has been met. For a primary designated offense, it's going to be a lot harder
Yeah.
to almost, I wouldn't say impossible, but it's extraordinarily difficult usually to succeed there. So be realistic. But on secondary designated offenses, I have counsel regularly say, like, we don't agree on this. That's fine, and I'll make a decision. One of my colleagues will. I know we had a couple other cases on here with respect to sexual assault law, just to bring them to people's attention. We don't have to spend a lot of time on them, just so we make sure we finish on our schedule. There was a case called Gorges from the Court of Appeal, 2024 ONCA 857. There are a few angles that are interesting about this case, including when the 276 regime applies for an offense that isn't technically enumerated there. But paragraph 51 has some really interesting language I would just bring to everyone's attention about these applications. For the Court of Appeal states, while it's commendable and in fact necessary for trial judges to guard against the misuse of evidence that could engage in myths and stereotypical thinking, that does not mean that all evidence regarding a complainant's involvement in sexual activity should necessarily be disregarded in every case. All of which is to say, approach these applications with caution. Okay? But if you can articulate a lawful basis for why it can be admitted and what use can be made of it, I know it's a big decision to bring one of these. You have to talk to the client, decide especially, if it's worth, I'm sure, the cost and the time and whatnot. But these can be argued successfully and professionally and done in a completely responsible manner. They're difficult, but they're not necessarily impossible. And I think some of the cases we've included will show you examples of where the appellate courts in this country have decided these are appropriate applications to grant. Just make sure you have the right backing for why you're doing it. You don't fall into the, obviously, I don't know, how should we say, swamp of twin myth-based reasoning.
Yeah, absolutely. And Gorgeous is the reason why I chose that is because I think it does a really good job of summarizing the AM decision where the Court of Appeal talked about the fact that 276 doesn't necessarily categorically apply to all proceedings where an accused person is not charged with an enumerated offense under 276, but it involves elements of a sexual nature. And ultimately in AM, they said, look, it doesn't automatically apply. It's got to be a case-by-case basis. You have to, take a look at the charges, the Crown's proposed evidence, and whether or not the defense themselves proposed to lead evidence of a listed offense. And obviously, this all comes on the heels of Barton, because you may recall that Barton is the case where even though it was not the offense was not one that was enumerated under 276, the Supreme Court of Canada found that an application would have been required in the circumstances. So just a really good case to have that summarizes the law as it pertains to non-enumerated offenses for 276. And what made this case interesting is that both the Crown and the defense actually raised other sexual activity in their questioning of the complainant, and the defense relied heavily upon it in cross-examination in order to illustrate that there were issues with the complainant's credibility. And there was no issue that was raised, firstly, by the Crown, and secondly, by the trial judge. And then ultimately, when the trial judge releases their decision, they reject a lot of the defense arguments because they say, oh, I'm not going to rely upon that because that's, that question dealt with 276 material and this was dealing with 276 issues, and I'm not going to let that affect the credibility of the complainant. So, that is a I think a big no-no where you don't give defense counsel the ability to respond to an area that you have concern about that you never raised before writing your decision. So I thought that this case was interesting for those 2 points, for the reiteration of what's in AM, and then for this really novel area of giving defense an opportunity to respond to any concerns you might have.
Feels important. I agree.
Yeah.
Okay.
Where did you want to go next, Your Honor?
Can we just segue into two of the sentencing decisions I wanted to talk about? And I'm just going to explain why I picked these two and what I think really the gems are within them for people. Habib 2024 ONCA 830. This is a really great decision written by the Chief Justice, Justice Tulloch, on how to deal with the principle of restraint with respect to a youthful adult offender. Okay, so, full disclosure, those of you who know me know that I spent most of my career as a lawyer in youth court, and then that's an area that I try to specialize in now as a judge as well. And of course, the Youth Criminal Justice Act has many provisions about appreciating the diminished moral culpability of youth. But what happens when you turn 18? Okay, you're a young adult and you commit an offense that's significant. Okay, what the Chief Justice does in this decision is explain why young adults should also be viewed, generally speaking, differently for more mature adults who are older. And what the Chief Justice writes in this case, and it is a serious case involving an offense with a firearm, right, is that because young adults are still maturing, they have high rehabilitative prospects, right? Often the mere fact that they're arrested or put through the court process or whatever can lead them to reflect on their lives and change. A pro-social path is generally available for someone so young, and that the principle of proportionality, right, requires the courts consider factors that decrease an offender's personal responsibility. And for a young adult, remember, not a young person under the WiCCD, but a young adult, immaturity is one such factor. And there's this just beautiful line or phrase that I believe the Chief Justice borrows from a decision from another court, where he says that while as adults they are morally responsible for their actions, full maturity and all the attributes of adulthood are not magically conferred on adults on their 18th birthdays. I think this is just such an amazing way of writing, which is such an important observation to make. So when I have a young adult before me, okay, this is what I find very helpful to hear from defense counsel. The Crown will rightly, I'm sure, focus on the crime itself and the impact on any victims. But if you can tell me about your client as a human being and the story behind them and what they're still doing in their life, and it's never wrong to emphasize this is someone who's still very young. But there's so many positive ways forward for them. And let's talk about that. And let's think about just who we're dealing with here. That can be very, very persuasive. And I would just invite everyone to keep this case in your back pocket for all of your young adult clients if they are found guilty and if sentencing is coming up. I just can't imagine the case where this wouldn't be helpful and a great way of synthesizing that precedent. The other sentencing case I just wanted to bring to everyone's attention is a decision out of the Nova Scotia Court of Appeal called COPE 2024 NSCA 59. This is just a fascinating case. We have a majority decision and a dissent that deals with what might be arguably described, right, as the conflicting values and maybe sentencing principles when you have an Aboriginal offender and an Aboriginal victim. And in this case, it's about a really serious crime of intimate partner violence. I don't think there's any downplaying how severe the offense was here. And the dilemma, right, for both the sentencing judge and then for the appellate authorities court is how should courts address the systemic over-incarceration of Indigenous peoples, but while also addressing what is arguably another extremely serious and pressing problem right now, which is just violence against women broadly, but violence against Indigenous women specifically. And in 2019, the criminal code was amended, right? And some of those provisions that were brought in there were meant to address emphasis on deterrence and denunciation and recognition of the harm done to vulnerable victims, particularly women, and in particular, Indigenous women. And this is where the sort of challenge with balancing often comes. And I can tell you, I'm given the privilege of sitting in our Gladue court in Toronto often. This is an issue that I have to struggle with somewhat regularly. And you see the majority decision out of the Nova Scotia Court of Appeal, I think focusing more on the fact that Gladue principles are not lost or diminished somehow in these cases. And then the dissenting judge saying all true, but we can't ignore the significance of those 2019 amendments. And perhaps is Parliament trying to rebalance the scales a bit in these types of cases? We'll see what happens. I don't know if that was sought leave to appeal to the Supreme Court of Canada. I'm sorry, I didn't check before we did this. It's inevitably going to come up in this province and in others over and over again. If it's an issue for you in a sentencing decision, go to this case. Both the majority and the dissent are very well written. Come at it from slightly different perspectives, but it will give you a lot to think about. And I would certainly want to hear from counsel on this issue and probably this decision in any case where I had to struggle with this.
Right. So are we still on sentencing or do we want to get into the evidence and charter cases?
I guess if I can just make mention of the two last cases that I had that dealt with with sexual offenses. The first case was Zachary, which was a Superior Court decision from September of 2024, and this dealt with the issue of the defense of mistaken belief in age. And I find that this case is really helpful, and if you're dealing with this situation, you're obviously going to be reading Hansen, which was a 2024 Ontario Court of Appeal decision. That's 2024 ONCA 369. But what the judge does in Zachary is essentially just distill the main points from Hansen in terms of, what is required in this type of defense, and ultimately really succinctly sets out, the steps in terms of when you're dealing with these cases, what's required from defense, and then what the onus on the Crown is. And at paragraphs 36, 37, and 38, the court does a really good job of just, simply stating what the test is. And essentially, there's an air of reality to the defense of mistaken belief. If the accused person has met that evidentiary burden, and if it's sufficient enough to permit the judge to find that the accused person believed that the complainant was the required age and took all reasonable steps to do so, then once that threshold is made, then the defense of mistaken belief in age becomes available for the judge to consider. And then the Crown then bears the onus, the burden to prove or to negate that defense beyond a reasonable doubt. And ultimately, if the trial judge is left with a reasonable doubt about any of those two aspects of the defense, then the defense of mistaken belief in age is available, and the accused has to be acquitted. And so I think it's a really good case to have in your back pocket if you are dealing with these types of or this type of situation, this type of defense, because this is going to be the way to spell it out, both for your client and obviously in your submissions for the trial judge. The last case that I did want to mention, unless Your Honor had something to add to that.
Nope.
No, was the Moran case. Moran was Ontario Court of Appeal decision. It was, I think it's the last appeal of Justice Obonsawin's Superior Court decisions before she was elevated to the Supreme Court of Canada. And this was, I like this case because it reminds defense counsel to stay vigilant about the use that the Crown or even the court may try to make of inadmissible evidence or evidence that cannot be used in the analysis. And in this case, what happens is the accused, who was a self-rep, provides in his testimony a number of messages between himself and the complainant. And ultimately, what ends up happening in the trial level is that the trial judge uses what the complainant says in those text messages to bolster her credibility and to bolster her version of the events. And as we all know, there are specific limits on the admissibility of prior consistent statements in a criminal trial. So this was a case where, for whatever reason, the trial judge decided that I'm going to use what the complainant says in these text messages to assist in terms of her credibility. Now, obviously, you need to be aware that any statements made by the accused in those text messages is admissible against the accused person in terms of assessing their reliability and credibility. But in this case, I thought it was a really interesting decision, not only from where it came from, but again, just to make sure that defense counsel is vigilant when we're dealing with these types of, or these pieces of evidence, and ensure that they are not being misused. And that, evidence like this, prior consistent statements, there are significant limits on the use that can be made of those. So I just thought it was interesting to reiterate that, if I can put it that way.
Thank you,
Uh,
Paolo. Yeah,
yeah,
go ahead.
the last two cases, and do we have a preference in terms of which one we go with? There's Campbell
No,
and then there is Charles. Maybe we'll start with Charles. So Charles is an interesting case from the Supreme Court of Canada because it's their first foray into the principled approach to the law of hearsay or the admissibility of hearsay when you're dealing with corroborative evidence. And we obviously are all aware of Justice Karakatsanis's decision and obviously Justice Moldaver's dissent in Bradshaw. And so this was the first case that the Supreme Court of Canada was dealing with that decided with this very, that dealt with this very same issue. And in this case, it was the accused wasn't charged with a very serious, well, I say very serious, but they were charged with pointing a firearm. And it was, I think it was a BB gun. And there was a witness, a third party that was involved, and the third party provided a statement to the police about what they had observed. Now, interestingly enough, that statement wasn't actually audio or video recorded. It was a written statement. And so obviously, when it came time to trial and the witness said, I don't know anything. I don't remember anything. I don't remember a thing. And no, that doesn't refresh my memory. There's obviously no procedural reliability that can be found in a written statement, right? So the Crown obviously had to rely upon on substantive reliability and looking at corroborative evidence. Now, what's interesting in this case is that the witness in that hearsay statement, in that written statement, had indicated that the accused had a gun, and the gun would be found inside the residence. And the police go and they search the residence and they find the firearm. And the Crown tried to use that to show that this corroborates the witness's statement, and it provides not only a ring of truth, but it meets the test for admitting hearsay evidence because it's been corroborated. He said that a gun would be found in the residence, the gun that was used, and lo and behold, the gun was there. Now, what's interesting is that the Supreme Court of Canada straight out says that's not enough, right? That is not enough. It doesn't confirm the material aspects of the statement that the Crown is trying to tender, right? It doesn't confirm the material aspects of whether or not the accused, handled the gun first and foremost, and secondly, whether or not the accused pointed it, right? It only partially corroborates the witness's version of the events, and it's not specific to whether or not the accused person had the gun, and there was no connection to confirm that the accused handled the pistol. And not only that, but that confirmation was not capable of ruling out other plausible alternatives. And Charles just, I think, it does. It reiterates the test in Bradshaw. Now, it's interesting because Justice Karakatsanis didn't actually write the decision in Charles, but it just essentially reiterates what the court said in Bradshaw, that's the test. And if the Crown or if defense are going to attempt to have hearsay evidence admitted through the principled approach, through substantive reliability and relying upon corroborative evidence, that corroborative evidence has to go to those material aspects of the statement. And if not, that statement's not going in. And I really like this case because it just, it reiterates how difficult hearsay evidence should be to get in a criminal trial, and the dangers that surround the admission of hearsay evidence. Now, we'll see when the composition of the court changes, and I think in about 5 years, whether or not Bradshaw and Charles are going to be re-reviewed. But for the time being, that's the law. And I think you just have to, if you're ever faced with a Crown application, just, point to these cases and say, look, the Supreme Court of Canada said that this kind of evidence should not normally be admitted, and there's an onerous test for the Crown to meet in order to have this evidence ruled admissible.
I really nothing much to add other than to say, I think after Bradshaw, people did wonder, did the Supreme Court really mean it? Well, yes, apparently they did, which is really what Charles stands for, right? And there's simply no escaping what you just got at there. There's a wonderful line in this decision in the sense that it clarifies the test. In the absence of a connection between the purported corroborative evidence and the aspects sought to be proved, right? The evidence is quite simply of no assistance in determining whether that specific aspect is true or accurate. In the few times I've had hearsay applications, this is always what I'm trying to focus on. Why does the Crown want to introduce this hearsay statement? What is it in that statement that is really important to the Crown's case? The fact that the witness said the sky is blue and they can confirm the sky was blue through other evidence, that's not what matters, right? What matters is that they identified the accused, or what matters is they point something else. And what, if anything, confirms or corroborates that core aspect of the statement? Right? So that's what you want to focus your analysis on.
All right.
Thank you.
The last case, Campbell, which was, I think Campbell was decided right in December, right at the end of the year. Campbell's an interesting case because you have
all the cases we're covering are interesting.
they're all interesting, but just the way that the court decided how they broke up. So there was a five-member majority, and then you have two sets of minorities. I believe it was Justice Cote on her own, as she's known to do, dissenting. But there were a number of issues that had to be decided in this case, and I'm just going to focus on the last part, which is dealing with exigent circumstances. But in Campbell, essentially what happens is the police arrest an individual, and that person has a cell phone on their person at the time of their arrest. And while the police are dealing with that accused, Campbell starts texting that phone and is trying to sell drugs that involve fentanyl. And so the police officers who have possession of that phone start communicating with Campbell and set up a drug deal, and then ultimately bust Campbell and arrest him. So in this case, the Supreme Court of Canada had to deal with a number of issues. First of all, whether or not Campbell had a reasonable expectation of privacy, and it was an 8-1 majority. I think Cote was the only dissent on that yes, he had a reasonable expectation of privacy in those communications. The second one was that the use of the cell phone was a Part 6 application required, right? As you know, in order to intercept private communications, the police are required to get authorization from the court. And there was a split on this, and the majority said no, it's not. Part 6 is not required, and for whatever reason, I even though the majority mentions, we have to take the language of Part 6 and kind of put it into today's, technological language and what we have in terms of technology today. I don't think they did so. And they rely on the fact that there wasn't any devices used to gain access to those messages, to those communications. And I think they lost sight of the fact that they're using a cell phone. They're using a device in order to gain access to these communications. So I didn't really like the analysis of the majority in the when it came to the Part 6. But putting that aside, in terms of the issue of the search, one of the first questions was this a proper search incidental to arrest? And the majority of the court said no, it wasn't a proper search incidental to arrest, and they relied upon Furon when it comes to searching cell phones incident to arrest. And so the issue comes to exigent circumstances. And this is where I think it gets interesting. And I think as defense counsel, when you're going to be dealing with, issues of searches when it comes to suspected fentanyl trafficking, you're going to run into a lot of issues. And I'm worried about what this decision may do um, for the issue of exigent circumstances. So um, essentially what the majority says is that the police had exigent circumstances to search that cell phone and to use that cell phone without getting prior judicial authorization. And in order to do so, they relied heavily on the fact that we were dealing with fentanyl, right? And um, fentanyl was really um, the vessel in which they were able to sail to exigent circumstances by saying that, the severe dangers of fentanyl, um, first of all, were highlighted by Justice Moldaver and Parento, but they repeat it and they talk about the fact that fentanyl can be fatal in very small doses. And they use that to substantiate the fact that there are exigent circumstances. They were worried that if they didn't make this deal with Campbell and Campbell brought those drugs to them, that Campbell would make deals with others, and then those drugs would enter into the community, and that was going to put the safety of the public at risk. Well, I mean, yeah, that's going to happen, but is it imminent? And are we certain that this drug is going to start causing deaths immediately? And I'm worried about the fact that police might see this decision, and in cases where they're dealing with suspected fentanyl trafficking, they're going to continue using Section 11 of the CDSA and these exigent circumstances to get past judicial authorization, and I'm worried about that. And I think this is a really good case to know, and make sure that you rely upon the strong language that is required for exigent circumstances. And to be fair, I know I've said I have my worries, but the court was careful to say that, look, this is not the presence of fentanyl alone is not going to amount to exigent circumstance in every case. But I mean, I think the language in this case is going to lead that to that ultimate conclusion that anytime you're dealing with fentanyl, you are dealing with exigent circumstances.
One thing I'll highlight from the decision, and then we can wrap it up here. It's just there's really great language in this case. Again, nothing new necessarily, but great language about remembering that the level of control someone has over information is not determinative on the question of standing. So if your client's phone or other personal information is somehow in the possession of someone else, and then that comes into the possession of the police, that does not necessarily mean that you cannot bring a Section 8 application, right? The language in the decision is really clear. Control is not an absolute indicator of a reasonable expectation of privacy, nor is lack of control fatal to a privacy interest. A person does not lose control of information for the purposes of Section 8, right, simply because another person possesses it or can access it. So this has been pretty clear since the Cole decision from the Supreme Court, I think back in 2012, about the teacher and the illegal material on his school computer. But, that should not be a barrier. And the analysis also has to be content neutral. So I would just say to everyone, when you bring these applications, don't lose sight of first principles. It's always good to ground your application accordingly. And if the Crown's going to try to argue exigent circumstances, that's fine. That's an argument that can be made. But I would be surprised if my colleagues were quick to accept that. That's obviously something that has to be heavily scrutinized and carefully looked at, even when dealing with serious offenses. And I'm not suggesting that fentanyl isn't very serious, or firearms, or what have you. But of course, the Constitution is extraordinarily important and serious too. And we do not want to see those fundamental rights eroded too easily, no matter how genuine and legitimate the law enforcement objectives are behind them.
On that point, you said about content neutral. There was a great line in the dissent by Justice Cote, and I'm trying to find it. I wasn't going to touch upon it, but it was interesting that essentially what she didn't agree with that approach to that issue and say, we should look at it from a content neutral perspective, because she said, if you do, that it leads to an inescapable conclusion that there is going to be a distinct possibility that the information contained within there is of a highly private nature, right? That the possibility is going to be there if you consider it all to be neutral, right? So, and in that case, you're going to find a reasonable expectation of privacy all the time. So, just an interesting case, and I'm sure we'll be seeing it used often in those circumstances of exigent circumstances.
All right. So I think that we covered the cases that we wanted to talk about. Thank you so much, both of you, for taking the time to review these cases. And I'm sure that it will be very helpful for many lawyers who will be watching this. It's a very nice way to summarize some of the important and key cases that came out in 2024. We will try to have a list of all these cases and the citations for those who want to have the links for them. Thank you again, both of you, and I hope to see you again soon on the series. So thank you for your time.
Thanks for having me. I really enjoyed this.
Always a great time. Thank you so much for doing these videos and for having us on.